Hello and welcome to HIV Justice Live, where we highlight the work that we and others are doing to advocate for HIV justice in conversation with fellow activists and allies. In today's episode, Doing HIV Justice, we're going to talk about working with prosecutorial authorities so they have a clear understanding of how to, and more importantly, how not to, use HIV criminalization laws. This is a good example of a harm reduction approach if you can't change or repeal laws. Adopting such guidance can hopefully result in fewer miscarriages of justice and improve the criminal legal system's approach to people living with HIV. And we have some brilliant guests on the show for you today. Kene Esom will talk about UNDP's new guidance for prosecutors. Lisa Power will discuss advocating for prosecutorial guidance in England and Wales. Richard Elliott will consider lessons learned trying to do the same in Canada. And we'll show excerpts from our Best Practices video documentary, Doing HIV Justice. So ever since England and Wales, and then Scotland, implemented their HIV-related prosecutorial guidance a decade or so ago, we've been hoping these could be replicated globally. And it hasn't been easy, which is why we're delighted that last month UNDP published guidance for prosecutors on HIV-related criminal cases, a crucial new tool to help support our advocacy efforts in limiting unjust prosecutions. Let's hear more about the guidance and welcome UNDP's Policy Specialist, Human Rights, Law and Gender, Kene Esom, who joins us today from Johannesburg. Welcome, Kene.
Thanks, Edwin. Glad to be on the show.
So, first of all, why did UNDP decide to publish this guidance?
So, prosecutors play a very important role when it comes to criminal cases in which HIV is an issue. And over the years, there have been recommendations from different places, UNAIDS, the Global Commission on HIV and the Law, lots of civil society advocates have raised the need to work with prosecutors on this issue. UNDP has typically worked with other actors, judges, law enforcement, and in 2018, coming out of the supplement of the Global Commission on HIV, there was an express request to have a guidance focused at prosecutorial authorities. This is a key resource for engaging prosecutors in using language, using processes, using principles that many of them are already familiar with using in their jurisdictions. We also think that this would be a useful tool for activists, for communities of people living with HIV who understand the impact of HIV criminalization laws, have often needed to engage with stakeholders in their countries, prosecutors, maybe judges, maybe public defenders, but have lacked a specific tool that speaks to that context. Ultimately, we want to see a decrease in prosecutions with HIV as a matter of prosecutions of people living with HIV, and hopefully one day to not have to talk about this at all because it will be in the past.
So one of the things that we at the HIV Justice Network have been doing from the very beginning is to use video to educate and hopefully to entertain. And back in 2012, our first ever documentary was about this very topic, how civil society worked with the Crown Prosecution Service for England and Wales to advocate for and then develop prosecutorial guidelines. The lessons from this 30-minute film are as relevant today, perhaps even more so now we've got global guidance to adapt, than they were back then. So I recommend everybody watches it in full. However, for today's show, we've put together a special 15-minute edit. And right after that, we'll get a chance to catch up with Lisa Power, who's featured in the documentary. Although most countries can and do prosecute potential exposure to the risk of HIV transmission, in England and Wales, only actual transmission is prosecutable. The law used is the Offences Against the Person Act of 1861, and the charge is either reckless or intentional grievous bodily harm. In October 2003, Mohammed Dika became the first person to be successfully prosecuted for recklessly transmitting HIV, taking everyone by surprise, including Lisa Power, Policy Director at Terence Higgins Trust, or THT.
It was incredibly messy to start with, and we all know the cases that got to court and what was actually finally prosecuted. But we were seeing, after the first reports of the Dika case and then the others got into the press, we were seeing all kinds of people suddenly being accused. The police were making it up as they went along. And the Crown Prosecution Service were trying to catch up with what was going on. And it was chaos out there, and that of course translated into an awful lot of very worried people with HIV.
So at what point did it become clear that the way forward was prosecutorial guidance?
Well, we wrote to the Crown Prosecution Service asking them to meet with us because it was chaos. But we didn't get a response. We wrote to them twice and didn't get anything out of them. And then Youssef from NAT had the bright idea of writing to the Commission for Racial Equality and copying them in. And of course that threat brought them round the table very fast indeed. So God bless Youssef, he found the key to make them pay attention to what we were trying to do.
Youssef Azad is the Director of Policy and Campaigns at NAT, formerly the National AIDS Trust.
There is an obligation on a public body in law in the UK, and that includes the Crown Prosecution Service, to work in a way that promotes equality and eliminates discrimination. We pointed out that the first three prosecutions were of African migrants, so there's a race equality dimension to what they were doing. There could be, going forward, if gay men were prosecuted, a sexual orientation equality dimension. And because people with HIV are disabled, deemed to be disabled in our legal system, there was a disability equality dimension. So the fact that the first three people accused and prosecuted were African was something that we responded to by reminding the public authorities of their equality duty and their equality obligations. And that letter broke through the silence and the obfuscation, and within a couple of weeks the process of developing prosecution guidance had begun.
And within the HIV sector, was there consensus that that was the way forward, rather than, say, attempt for law reform or any other way?
There were a lot of different opinions, but the majority of people in the sector didn't want the law involved at all. They didn't want anything to be against the law. And Youssef and I kind of stood out. Our agencies were very clear that you couldn't have nothing ever being an offence, that just wasn't going to wash. We knew that changing the law was unlikely to happen, and even if it did happen, it wasn't even that there was no guarantee it would go our way. It was highly likely not to go our way. We could have actually ended up with a specific penalty for HIV transmission that was even more draconian.
So can you remember what the early process was like in terms of the first meeting and who was there, and what kind of discussions were had at those early meetings?
I think it's fair to say that once we got them to come to the table with us, the senior officers at CPS were happy to do the process. And then Arwell came into post, who was the third direct officer to deal with the issues, but who was just wonderful and just said, this is what we need to do, we need to get everyone around the table, who else should we have on a committee, what can we do? And things just moved very, very fast once Arwell was in there.
Arwell Jones is head of the Law and Procedure Unit at the Crown Prosecution Service Strategy and Policy Directorate.
We recognise that these cases really threw up issues which did not arise in the majority of prosecutions. There were obviously social sensitivities, and this was about the law becoming involved in what were essentially private acts. But also there were issues of science as well. The CPS over its history has been developing a body of guidance addressing different specific areas. We recognise that different types of crime or different types of offender or different types of victim threw up different issues.
The Crown Prosecution Service were responsible for the invites to all of the justice people and the police and so on. But Youssef and I did get quite a say in who was invited from the community and from the medical side, which enabled us to ensure that we had people who were going to be constructive around the table and no shouting.
And once it became clear that the real heart of this guidance needed to be the addressing of scientific issues, at that stage we then contacted the government's chief medical officer. And at that stage, various clinicians and virologists were brought in to provide their expertise as well.
We would not be where we are without the support of HIV doctors and virologists who were concerned about the possible impacts of the prosecutions and willing to help us.
Were you more open to hearing this from expert virologists than perhaps from civil society who knew about these things but weren't expert?
Our guidance, which would be publicly available and open to scrutiny, could at any stage be the subject of a judicial challenge. And were we put in a position of our guidance being judicially challenged, we would need to be able to justify why we'd reached the position that we had. So it was for this reason that we felt that we had to also engage those with the scientific and expert knowledge on these various issues. Although scientific and forensic evidence has a long time been part of the prosecutor's armoury, this was the first time really where we had complex scientific issues which needed to be resolved in order to prove an actual crime.
Yeah, it's actually interesting because during the process of the consultation for the guidance, you had the case at Kingston Crown Court, which was the first time that the limitations of HIV forensic evidence was highlighted by an expert witness for the defence, and that resulted in the first not guilty verdict. Was it welcomed because it was actually seen to be an intervention of science in a way that you hadn't appreciated before, or were you actually disappointed that previous cases had not highlighted this as an issue?
It was clearly valuable because it increased our knowledge in this area. It was a useful opportunity for us to take back and reflect on our knowledge. We may well, not just the prosecution authorities, but the criminal justice system as a whole, may well have been lured into thinking that science provided more concrete answers than actually was the case in this particular scenario. We obviously had fingerprint evidence and DNA evidence, which in themselves often provide compelling evidence against a particular suspect for a crime. It was evident the more we discovered around phylogenetic science that the same assumptions did not apply here.
But how was it possible for Yusuf and Lisa to work constructively with the CPS when civil society generally opposed prosecutions for reckless HIV transmission?
One of the interesting and important points in the process was, even though we were there in the working group, we made clear that whatever the CPS produced would be the CPS's document, not ours. And the desire to have guidance and to mitigate some of the harms that were arising didn't affect our fundamental opposition to the prosecutions happening at all.
Well, we started off trying to argue recklessness out, but that was clear that wasn't going to happen. I mean, the Crown Prosecution Service had a very clear view that they don't make the law, they just implement it, and that law was there, it had already been used. So we very much took the line of trying to mitigate the use of it and try to curb the abuses of it that we were seeing happening.
It's important to note that the CPS policy and guidance is not specifically about HIV, but rather about the intentional or reckless sexual transmission of infection. That also created some challenges in terms of getting the balance right between being HIV specific where it was necessary, but making sure the guidance covered all sexually transmitted infections. One solution was the use of the term reasonable safeguards, rather than explicitly referring to condoms. This term later also encompassed another reasonable safeguard, that of an undetectable viral load on antiretroviral therapy.
Yes, well, we purposely made this a generic guidance document because, of course, the law in this country does not discriminate between different infections. And any infection which was capable of causing harm, or in particular serious harm, would be susceptible to prosecution. And it was for that reason that we kept this as a generic document.
The guidance was finally published on the 14th of March 2008. This was followed by a THT report, Policing Transmission, that concluded that the scope and approach to police investigations went beyond what the law intended. NAT then worked with the Association of Chief Police Officers to create guidance for the police, which could not have been done without the CPS policy and guidance providing clarity on the law. We caught up with Lisa, Youssef and Arwel at the CPS's Central London offices to talk about lessons learned. It's now 4 years since the first guidance came out.
We're really pleased with this process and proud of it, actually. It's brought immense benefits. To recap, some of the key points, I think, were having clear expectations of what could and what could not be achieved, asking the prosecution service to do things that they were able to do, not asking them to do things they were not able to do.
Once we'd got the guidance, the key subsequent lesson was it's great to have guidance, but it's not enough. You actually have to get the word out there about it. And we very much learned that the guidance is only as good as the prosecutors who are using it. And if they're not using it, there's still a need to do a great deal of liaison. That's what's been really good about the ongoing relationship with Arwel and with the CPS policy unit, has been for me the ability to actually discuss cases, to actually say, I think something might be going wrong here, are you sure these people, and just check in that the cases are known to central CPS and are proceeding properly.
What would you recommend to other prosecutorial authorities who are being approached by the equivalents of Lisa or Youssef around the world?
It's the hallmark, really, of a mature and transparent and accountable prosecution service to open up its processes, to show how it goes about its business, how it makes its decisions, and to invite comment and feedback from those who have a stake in that.
And so, Lisa and Youssef, conversely, what would you suggest to civil society organisations, people working in the HIV world, who are trying to advocate for guidelines?
I don't want to say be nice, but I mean, it's about tone and approach and a recognition that prosecutors have a job to do, and it's an important public service. So the fact that we approach the CPS not all guns blazing and criticising them for doing their job, which is to apply the law, but rather constructively saying there are a lot of unknowns, there are a lot of issues that you may not have thought of because you're not HIV experts, no reason why you should be. We might be able to help you think through some of these. And that was, I think, particularly important. So there's the whole issue of approach and being constructive and offering a solution.
Don't be utopian. You're not going to get everything that you want, or it's highly unlikely that you will. Be pragmatic about what the possibilities of the process are. Also, as Youssef says, find the levers, find what will encourage prosecutorial authorities to work with you. Collect the evidence that things aren't working, so that the prosecutorial authorities can see that it's in their own interest to be working with you rather than simply going their own way. And be persistent. If we'd given up after they didn't answer the first couple of letters, nothing would have happened. I mean, it was a long process. It didn't happen anything like overnight.
The full-length 30-minute version of this documentary is available on our YouTube channel, and it'll give you even more insight into the development process, especially how the science around HIV played a key role in the guidance. Remember, this was filmed in 2012, before all the studies proving U equals U was definitively true. And the film ended quite optimistically, but we all know that happily ever after is something of a myth. So did the guidance really end all unjust prosecutions? And to answer that question and more, I'm delighted to welcome live from Cardiff, Lisa Power.
Hi.
Hi, Lisa. So welcome. I know it's been a while, but Lisa, I have to ask, what happened after the happy ending we saw in the film? I mean, was it all fine? Were there no more inappropriate investigations and prosecutions?
Well, I think, the lesson that I want everyone to take away from this is it's great to have guidelines, but you have to make sure that they're working and that they're being used. What we did was the guidelines were created around 2008. We went back in 2013 and we looked at 13 cases which had gone as far as court. and been, where charges have been laid subsequent to the guidelines being created, and looked at whether they had actually been properly implemented or not. And that was a really useful piece of research. And it was useful both for civil society to see what was going wrong from our end, but also for the Crown Prosecution Service to see where there were glitches in the process. And it was, it was used by them. And there's been a couple of attempts subsequently by the Crown Prosecution Service to alter the guidance, because sometimes you realise the goalposts might have shifted a bit more than you thought they had. And on at least 2 occasions now, there's been quite a pushback from the Crown Prosecution Service, and it's been really, really important that civil society was still there, was still keeping an eye on cases, and was able to push back when new people who followed in Orwell's footsteps were a little more combative about what they might want to change again about the procedures. So, keep on your toes.
I mean, you gave some absolutely brilliant advice in the film, absolute nuggets. But my favorite was the one where you said, make sure you can find people who are constructive and no shouting. Which to me, that was all that it summarized really a lot of the problems that I think that advocates are going to face, which is, many of us feel very strongly, very passionately about HIV criminalization. We think of prosecutors as the enemy. And I think it's important that the approach that you and Yousef took was a much more considered, pragmatic one. But how did you persuade the no shouting part of it?
I think a couple of things happened. I mean, one was we were polite but pushy. I mean, we didn't give up, and I think that's incredibly important. But you can do that without being aggressive. And I'm afraid what we did do was we rather upset some people on our own side who were excellent people within the movement against HIV criminalization, but who round that table would certainly have put people's backs up. We were ruthlessly pragmatic between Yousef and I. We wanted the clinicians in, we wanted it widened to the rest of sexual health, but we also made sure that everyone who came in understood that this was about persuasion and not about, banner waving or anything like that. Not about shouting at people, because they would just have battened down the hatches. I mean, you've got to remember that not only did we have prejudices about the prosecutors had prejudices about us. You have to take both those sides into account in this.
Although it was a long journey with a number of twists and turns along the way, Lisa and Yousef's experience of advocating for prosecutorial guidance in England and Wales was ultimately successful. And that inspired others working to limit the overly broad use of the criminal law, including in Canada. And to learn about their experience, I'd now like to welcome the Executive Director of our close Canadian HIV Justice Worldwide partner, the HIV Legal Network, Richard Elliott, who joins us live from Toronto. Good morning, Richard.
Hi, Edwin. Lovely to be here.
So Canada's had some really problematic approaches to HIV criminalization. And it's no wonder you decided to try and replicate that approach. How did that go, though? I mean, what lessons did you learn from those experiences?
Well, I think that it was important for us to go through a process of educating communities. And there was an entire coalition that was ultimately formed across the province of Ontario to explore what would be the potential value of having such guidance in place for prosecutors. As you said at the beginning, it is an exercise in harm reduction. It is not an exercise that can change the substantive law that prosecutors are working with, but it's an effort to change how and when they decide to apply that law and to advance their understanding of why it's not necessarily the proper response in a number of circumstances that were still, in fact, being pursued through prosecutions. And so we undertook collectively this province-wide consultation and presented a draft of what we thought should go into such guidance. And here is where the story diverges a little bit, perhaps, from the experience in the UK, and I might draw a slightly different lesson than Lisa about the no shouting, because while that would be ideal, the experience proved in our instance over time that there was going to be very little progress with the prosecution services and the prosecutors that were basically calling the shots within the Ministry of the Attorney General, unless and until there was some political heat brought to bear. And frankly, the experience here has been at virtually every turn that unless and until you bring that political pressure to bear and get some sort of direction from on high, the prosecution services will not budge on this.
So you've had a lot of experience fighting HIV criminalization on many fronts. And in fact, you and your colleague, Cecile Kazatchkine, developed the guidance for UNDP. So you're very familiar with its content. So how do you imagine this could be adapted to something that's got local relevance?
I think there are a few things to take into account. The first is that you need to figure out in your jurisdiction, who is it or which body is it that has authority in your legal system to actually issue or adopt some sort of policy or guidance or directive that would influence or govern the conduct of prosecutors in individual cases. So you need to know who the key decision maker is that you need to engage. Secondly, you need to give some thought to the form that such policy or guidance might take, because that too will vary from jurisdiction to jurisdiction. Is it an official binding directive? Is it some sort of memo that goes out from the chief prosecutor to all individual prosecutors? Is it something that's published in an official government publication? Those things vary. And so you need to think about what it is you're looking to have produced at the end of this process by having some regard to what the normal form of these things is in your jurisdiction normally. Third, you need to think about the substantive law that you're going to have to engage with, because if you're in a jurisdiction that only criminalizes transmission, for example, as opposed to one that is broader and criminalizes exposure, well, then that's going to play into what kind of language you might be looking for in your guidance. And here, I think the UNDP resource is relevant to you in many respects, regardless of the substantive law, but you do need to tailor it and customize it. I think finding some compelling examples to help make your case about unjust prosecutions and why, therefore, there should be something that would limit prosecutorial discretion in some way will be important. And then finally, I think it would be great to think about having scientists on board, because that's going to be a key part of the argument about limiting the scope of the law. It's by no means the only line of argument that needs to be advanced. There are other important issues at play, but it is a key part of the advocacy strategy, and the guidance speaks to that as well.
So Dennis, what's been going on Facebook, YouTube, and Twitter?
Quite interesting. As you know, the guidance was just recently launched, and people are just sucking it in, getting to understand what the guidance are for, and hopefully getting to see that they actually work. They actually advise the court and judicial process and system. We had one key question, okay? How do we ensure that the prosecutors do not use the same guidance to prosecute anew or examine new cases with the new evidence, with the new eyes? And I think that is a question posed to the panelists.
Well, obviously I can only speak for our experience in the UK, but from my experience, prosecutorial guidance generally mitigates what's taken place, and if anything, they should be re-examining previous cases which were miscarriages of justice. And secondly, if by some really long shot it was the other way around, they're swamped with cases on an ongoing basis of all kinds of things. So I think the odds of that are extremely rare, but frankly, we should, when we're doing these kinds of negotiation with prosecutors in our countries, we should always be mindful of not opening up new avenues for them to inappropriately prosecute. That is a key part of it.
What would you say is the most effective strategy to convince prosecutors that they need guidance on HIV-related criminal cases? Let's start with Lisa.
Get the evidence. Actually monitor the cases that are happening, show the injustices that are happening, and in terms of what will make prosecutors pay attention, show them the money and the time that they're wasting, as well as the injustices they're perpetrating. Because frankly, you get them one way or the other. If they're not interested in human rights, they're probably interested in their budget line.
if you have an instance in which there is some very apparent injustice in a person being prosecuted in those circumstances, that tells a story of personal injustice, not just scientific misinterpretation, I think that makes it all the more compelling as well, including for a broader audience to whom you might need to communicate your message about the need for a change in prosecutorial policy or practice.
Even though this is a guidance tailored primarily to prosecutors, we hope to be able to see judges refer to it. And oftentimes we see that when judges in courts either raise such guidance, such normative standards in the course of proceedings before them, they also often make the prosecutors go back and think about the issues raised, respond to it one way or the other. And oftentimes we hope, certainly with this guidance, that that will be one way to get prosecutors thinking about this and get this being used effectively in courts.
I'd like to thank all of our guests today, Kenny Esom, Lisa Power, and Richard Elliott. Thanks to our brilliant director, Nicholas Feustel, Julian and Dennis and the rest of the HJN team. And thanks also to our funder, the Robert Carr Fund, and of course to all of you for watching and commenting. See you soon for the next HIV Justice Live.